Torts bar exam essay recall. Intentional torts. There are 7 intentional torts: mnemonic, baffic, battery, assault, false imprisonment, IIED, trespass to land, trespass to chattels, conversion. Every intentional tort has 4 prima facie elements. Mnemonic, vic. 1. Voluntary act. 2. Intent, meaning purpose or substantial certainty. 3. Causation, the outcome resulted from the defendant's act. 4. Specific elements of that tort. Battery. 3 elements. 1. Intentional causing. 2. Harmful or offensive contact. 3. With another person, the defendant intentionally caused harmful or offensive bodily contact with the plaintiff. Contact is harmful or offensive if it causes physical harm or would offend a reasonable sense of personal dignity. Assault. 4 elements. 1. Intentionally placing a person. 2. In reasonable apprehension. 3. Of imminent. 4. Harmful or offensive contact. The defendant intentionally placed the plaintiff in reasonable apprehension of imminent harmful or offensive contact. The plaintiff must have actually perceived the threat, though fear is not required. False imprisonment. 3 elements. 1. An intentional act of restraint. 2. On another person. 3. Causing confinement within a bounded area. False imprisonment requires an intentional act of restraint that confines the plaintiff within a bounded area. Confinement exists where the plaintiff's freedom of movement is physically restricted, or where imminent unlawful force is threatened, and no reasonable means of escape exists. The plaintiff must be aware of or harmed by the confinement. IIED. 3 elements. 1. Extreme and outrageous conduct. 2. That intentionally or recklessly causes. 3. Severe emotional distress. IIED requires extreme and outrageous conduct, meaning conduct utterly intolerable in a civilized community, that intentionally or recklessly caused the plaintiff to suffer severe emotional distress. A medical diagnosis is not required, but may establish severity. Trespass to land. 3 elements. 1. Intentionally entering, or remaining on, or causing another to enter or remain on. 2. Another person's real property. 3. Without permission. Trespass to land requires that the defendant intentionally entered or remained on the plaintiff's real property without permission. Damage is not required. The property includes airspace above and ground below. Under the modern view, intangible invasions may also constitute trespass. Trespass to chattels. 4 elements. 1. An act. 2. That intentionally. 3. Interferes with. 4. Another's personal property. The interference must cause dispossession, physical harm, or reduction in value. Conversion. 3 elements. 1. An act causing. 2. Serious and substantial interference with or destruction of. 3. Another's personal property. Conversion requires an act that causes serious and substantial interference with or destruction of another's personal property. Where the interference is sufficiently serious, the defendant must pay the full fair market value. Transferred intent. 2 rules. 1. Intent as to one tort qualifies as intent for another. 2. Intent directed at one person qualifies as intent directed at another. Applies to 5 torts only: mnemonic, baft, battery, assault, false imprisonment, trespass to land, trespass to chattels. IIED and conversion do not get transferred intent. Under transferred intent, intent to commit one of the 5 covered torts transfers to the tort actually committed, and intent directed at one person transfers to any person actually harmed. Eggshell skull. Once the prima facie case is established, the defendant is liable for the full extent of all damages even if unforeseeable. Defenses to intentional torts. 9 defenses. Mnemonic, extendress, consent, self-defense, defense of others, defense of property, necessity, discipline, recapture of chattels, arrest, shopkeeper's privilege. Consent. 3 types. 1. Actual willingness. 2. Apparent consent. 3. Implied consent as a matter of law or policy. If the defendant exceeds the scope of consent, liability attaches for any additional harm. Consent obtained through fraud, trickery, or from a person lacking capacity is invalid. No one can consent to an illegal act. Self-defense. 3 elements. 1. Use of force. 2. To protect oneself from a threat of imminent. 3. Unlawful force. The belief must be reasonable. Retreat is not required under the majority rule. The minority rule requires retreat before using deadly force, but never if the actor is in her own home. Force must be proportional. The initial aggressor cannot claim self-defense unless they communicate withdrawal, or the other party suddenly escalates. Self-defense requires proportional force against an imminent unlawful threat based on a reasonable belief. Majority rule. No duty to retreat. Deadly force only, When deadly force is threatened, initial aggressor may not claim self-defense absent withdrawal or sudden escalation. Defense of others. Same rules as self-defense apply to protecting a third party from the threat of imminent unlawful force. Defense of property. 2 elements. 1. Use of force. 2. To prevent an ongoing or imminent tort against one's property. A request to desist is required unless dangerous or futile. Deadly force is never allowed to defend property. Necessity. 3 elements. 1. Actions that reasonably appear necessary. 2. To prevent an imminent. 3. Substantially greater threat of harm from a natural force. Public necessity. Harm threatened the public at large. Complete defense. No damages owed. Private necessity. Harm threatened the defendant or a limited group. The defense applies but the defendant remains liable for actual damages caused. Discipline. A parent may use reasonable force or confinement as reasonably necessary for discipline, control, or education of a child. Recapture of chattels. 5 elements. 1. Use of reasonable. 2. Non-deadly force. 3. To regain possession. 4. Of property recently. 5. Unlawfully taken. Hot pursuit required. Arrest. A police officer or private person may use force to effectuate an arrest if the arrest was lawful and force was reasonable. Shopkeeper's privilege. 2 elements. 1. Reasonable ground to believe. 2. Person recently engaged in shoplifting. Detention must be for a reasonable time using reasonable means. Negligence. 5 prima facie elements. Mnemonic. Duty. Breach. Factual causation. Proximate causation. Actual harm. Duty. Everyone has a duty to act as a reasonable person. No duty exists if the plaintiff was unforeseeable, or liability would be crushing as a matter of public policy. No general duty to rescue or control third parties. A duty arises in 6 situations. Mnemonic. Civisk. Special relationship. Invited the public. Voluntarily undertook rescue. Agreed to work together. Created the danger. Statute imposes a duty. Landowner duty. 3 categories. Trespassers, licensees, invitees. Adult trespassers. No duty. If known or anticipated, must warn of human-made conditions posing risk of death or serious bodily harm. Child trespassers. Attractive nuisance. 5 elements. 1. Human-made condition posing unreasonable risk to children. 2. Landowner knows or should know of both condition and risk. 3. Landowner knows children are likely to trespass. 4. Child unlikely to appreciate the risk due to youth. 5. Burden of precaution is low relative to the risk. Licensees. Must warn of or make safe known dangers. Invitees. Reasonable care as to activities on the land, known dangers, and dangers discoverable with reasonable inspection. Standards of care. Reasonable person under the circumstances. 7 exceptions. Serious physical impairment. Child of similar age and experience. Professional and sane community. Special knowledge or skill. Emergency unless self-created. Bailey based on who benefits. Landowner or possessor. Proving breach. For methods. Hand formula. Breach of burden of precaution is less than probability of loss multiplied by gravity of loss. P less than P times L. Custom. Evidence of the standard of care but does not dictate the outcome. Negligence per Southeast. 3 conditions. 1. Plaintiff in the class the law was designed to protect. 2. Law designed to prevent the type of harm suffered. 3. No excuse for noncompliance. Res ipsa loquitur. 3 elements. 1. Event would not ordinarily occur without negligence. 2. Instrumentality solely within defendant's control. 3. Plaintiff's own fault did not contribute. Factual causation. 2 tests. But for causation, or substantial factor where multiple defendants could have caused the harm. 3 special rules. Alternative liability. All defendants must prove they were not the cause. Applies to small groups. Market share liability. Each defendant liable for proportional market share. Applies to large groups. Joint tortfeasors. All treated as causes when acting within scope of a joint venture. Proximate causation. The injury must be foreseeable. An unforeseeable intervening force is a superseding cause that cuts off liability. Eggshell plaintiff. If the type of injury was foreseeable, defendant is liable for the full extent even if the scope was not. Proximate cause requires a reasonably foreseeable injury. An unforeseeable intervening force is a superseding cause. Under the eggshell plaintiff rule, the defendant is liable for the full extent of harm, where the type of injury was foreseeable. Actual harm. The plaintiff must suffer physical injury or property damage. Emotional harm alone is insufficient. Attorney fees not recoverable. Punitive damages require willful, wanton, or malicious conduct. Need. For situations. 1. Plaintiff in the zone of danger, with severe distress and physical symptoms. 2. Plaintiff observed a close relative suffering physical harm. 3. Defendant damaged the dead body of a close relative. 4. Defendant misinformed the plaintiff that a close relative died or was seriously injured. Defenses to negligence. 4. Mnemonic. PMCO. Pure comparative. Recovery reduced by plaintiff's percentage of fault. No bar to recovery. Modified comparative. Type 1. Plaintiff recovers only if less than 50% at fault. Type 2. Plaintiff recovers if 50% or less at fault. Contributory negligence. Slightly negligent plaintiff recovers nothing. 3 exceptions. Last clear chance. Defendant violated a safety statute, or defendant was reckless or intentional. Assumption of the risk. Plaintiff knowingly and voluntarily encountered a known risk. Significantly limited in comparative negligence jurisdictions. Vicarious liability. 5 categories. Mnemonic. CSEDS. Parents. Car owners. Employers. Dram shop. Social host. Parents. Not vicariously liable unless the child is acting as their agent. Car owners. Liable when they permit another driver to use their vehicle, and that driver causes an accident. Employers. Liable for employee torts within the scope of employment. 3 scope factors. 1. Employee was doing the kind of work they were hired to do. 2. Tort occurred during the time and space of employment. 3. Conduct was motivated by the desire to serve the employer. Intentional torts are outside scope unless the employee's role created the opportunity. Frolic breaks the chain. Detour does not. Non-delegable duties. Employer liable for independent contractors. When work is inherently dangerous, occurs in a public place, or affects the public at large. Parent agency. Liability attaches when the hirer represented the contractor as an employee, and the plaintiff reasonably relied to their detriment. Dram shop. Liable for serving alcohol to a minor or additional alcohol to a visibly intoxicated adult. Social host. Similar to dram shop for non-commercial providers. Most jurisdictions require knowledge the consumer was a minor. Apportionment of fault. For rules. Mnemonic. JSCI. Joint and several liability. Plaintiff may recover the full amount from any one defendant when more than one caused a single injury. Several liability. Recovery limited to the defendant's proportional share of fault. Contribution. If one defendant pays more than their share, they may recover the overpayment from co-defendants. Indemnification. A defendant may shift liability to another unless barred by the wrongful nature of their own conduct. Strict liability. Abnormally dangerous activities. No fault required. 2 conditions. 1. Uncommon in the location where carried on. 2. Highly likely to cause physical harm that cannot be eliminated through reasonable care, and potential harm outweighs community value. Animals. 3 rules. Wild animals. Strictly liable when dangerous propensities cause foreseeable injury. Domestic animals. Strictly liable if owner knew or had reason to know of dangerous propensities. The 1-bite rule. Livestock. Strictly liable for trespass. Defenses to strict liability. 2. Comparative negligence reduces recovery. Assumption of the risk bars recovery if plaintiff knowingly and voluntarily encountered the risk. Products liability. Prima facie case has 4 elements. Mnemonic. CDEF. Commercial seller. Defective product. Existed when it left defendant's control. Foreseeable injuries. 3 types of defect. Mnemonic. MDW. Manufacturing defect. An intended production error makes the product more dangerous than intended. Design defect. The intended design itself is unsafe. 2 tests. Risk-benefit test. Benefits of an alternative safer design clearly outweigh the costs. Consumer expectations test. Product is more dangerous than an ordinary consumer would expect when used as intended. Failure to warn defect. Warnings do not adequately convey the nature and extent of a foreseeable danger. Read and heed. Courts presume the plaintiff would have read an adequate warning. Learned intermediary rule. Drug manufacturer satisfies its duty by warning physicians. Obvious dangers require no warning. Defenses to products liability. 4. Mnemonic. CIEM. Comparative negligence reduces recovery. Implied assumption of the risk. Traditional rule bars. Modern rule reduces. Express assumption bars recovery if plaintiff knowingly and voluntarily assumed the risk. Product misuse bars liability unless reasonably foreseeable. Warranty claims. 3. Express warranty. Created by promise, statement of fact, description, or sample. Cannot be disclaimed by general disclaimers. Implied warranty of merchantability. Goods of fair average quality fit for ordinary purpose. Requires merchant seller. Can be disclaimed in writing. Implied warranty of fitness for a particular purpose. Seller knows buyer's specific purpose and that buyer relies on seller's judgment. Nuisance. 2 types. Private and public. Private nuisance has 3 elements. 1. Substantial interference. 2. Unreasonable interference. 3. With the use and enjoyment of land. Defendant must act intentionally, negligently, or recklessly. Public nuisance. An unreasonable interference with a right the general public possesses. Private plaintiffs must show harm particularized from the general public's harm. Defenses to nuisance. 3. Comparative negligence. Only when nuisance is based on negligence. Assumption of the risk. Coming to the nuisance. Traditional rule is a complete bar. Modern rule courts balance substantiality and unreasonableness. Remedies. Monetary damages are automatic. Injunctive relief requires inadequate monetary damages and equitable factors favoring the injunction. Defamation. Prima facie case has 6 elements. Mnemonic, default. Defamatory statement. False statement of and concerning the plaintiff. Publication. Fault. Damages. Slander is spoken. Libel is written or broadly disseminated. Per quad requires extrinsic evidence. Per southeast is defamatory on its face, and damages are presumed. Fault. 3 standards. Public official or public figure. Actual malice. Knowledge of falsity or reckless disregard for truth. Private person. Matter of public concern. Negligence. Private person. Not a matter of public concern. No fault required. Damages presumed without proof in 4 situations. 1. Private person. Not a matter of public concern. 2. Public official or public figure. 3. Accusations of a serious crime, loathsome disease, sexual misconduct, or conduct incompatible with one's business or profession. 4. Slander per southeast. Defenses to defamation. 4. Mnemonic, tack. Truth, complete defense. Absolute privilege, covers judicial proceedings, legislative functions, and spousal communications. Qualified privilege, covers former employer references, self-defense statements, legislative testimony, and criticism of artistic works, overcome by proving intent, recklessness, malice, or overpublication. Consent. Complete defense if scope is not exceeded. Invasion of privacy. 4 types. Mnemonic. IAPF. Intrusion upon seclusion. Appropriation of name or likeness. Public disclosure of private facts. False light publicity. Intrusion upon seclusion. Reasonable and actual expectation of privacy, upon which the defendant intruded, in a way highly offensive to a reasonable person. Appropriation of name or likeness. Defendant used the plaintiff's name, photo, or recognizable feature, without permission, in commercial advertising. First Amendment protects newsworthy and creative uses. Public disclosure of private facts. Publication highly offensive to a reasonable person, not a matter of public concern. Truth is not a defense. False light publicity. Defendant spread a falsehood about a private person to a large number of people. The statement is highly offensive, done knowingly or with actual malice. Defenses. Consent is generally available. Absolute and qualified privilege apply to false light and public disclosure claims. Truth is a defense to false light, but not to public disclosure of private facts. Misrepresentation. 2 types. Fraudulent and negligent. Fraudulent misrepresentation. 4 elements. 1. Intentional misrepresentation of material fact. 2. Intent to induce reliance. 3. Actual and reasonable reliance. 4. Pecuniary damages. Material fact is one a reasonable person would care about or the defendant knew the plaintiff cared about. Puffery and opinions are not material facts. There are no defenses to intentional misrepresentation. Negligent misrepresentation. 4 elements. 1. Negligent statement of materially false information. 2. In the course of a business or profession. 3. For the economic guidance of others. 4. Reasonable reliance to the plaintiff's detriment. Defenses. Comparative negligence, contributory negligence, and assumption of the risk. Other torts. Intentional interference with business relationships. 4 elements. 1. A valid contract existed. 2. Defendant engaged in wrongful conduct. 3. Defendant intended to and did cause a breach. 4. Plaintiff suffered damages. Defense. No liability if defendant disclosed truthful facts, or was protecting a legitimate interest in good faith. Abuse of process. Instituting a legal process with a wrongful or ulterior motive. Malicious prosecution. 3 elements. 1. Party instituted a legal proceeding without probable or reasonable cause. 2. Knew the claim was baseless, or acted with malice. 3. The proceeding was resolved against that party. Immunities. Federal government. Lawsuits may be brought if administrative remedies are exhausted, and suit is brought in federal court. No jury trial. Federal employees acting within scope of employment cannot be sued individually. State government. Suits allowed when acting like a private party, barred when acting purely as government. Parents. Children may sue for intentional torts. Parents retain the privilege to use reasonable force for discipline. End of torts review. Repeat from the beginning.